Ronald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in the first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson.
The moment the video opens, we're thrown straight into Judge Coleman's courtroom, where the sovereign citizen reappears with the exact same misplaced confidence as before. His entrance sets the tone. A man convinced he understands the law better than the entire judicial system, yet unable to articulate a single coherent legal concept. Judge Coleman's calm, steady demeanor contrasts sharply with the plaintiff's erratic, pseudo-legal language, creating an immediate tension that pulls the viewer in. The court clerk's announcement underscores the seriousness of the setting, which only makes the sovereign citizen's behavior look more clownish. This first interaction frames the entire case as a battle between structured legal procedure and a man determined to operate from fantasy rather than fact.
See that there is let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. And why are you following?
As the judge calls for appearances, the attorney representing Officer Ambrose speaks professionally and efficiently, highlighting the stark difference between legitimate legal advocacy and sovereign citizen theatrics. He confirms the filings, motions, and procedural posture without adding drama, essentially embodying what a courtroom is supposed to sound like. Then Grayson introduces himself with unnecessary flair, labeling himself as representing himself as though this declaration carries mystical authority. The narrator cuts in with deadpan humor about the Vaseline filter, emphasizing how sovereign citizens often try to hide their confusion behind false confidence. This part captures the comedic imbalance between trained legal professionals and individuals who rely on internet scripts instead of basic understanding.
That's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36 District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did read copy of the request for default this week, so I had no opportunity to respond. Obviously, the city the city law department who's representing this police officer filed its motion back in June, dismissed in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court to...
When the judge asks Grayson to explain the legal basis for his request for default judgment, the sovereign citizen immediately abandons the question and launches into his identity claims, announcing he is a Moorish American national. This rhetoric, while familiar to anyone accustomed to sovereign citizen ideology, has no relevance in a civil case, and the judge instantly recognizes the evasion. The commentary notes how Grayson's argument has no logical connection to his legal motions, highlighting the disconnect between his beliefs and the functioning of real courts. Judge Coleman presses for clarity, but Grayson continues drifting into unrelated declarations, revealing that he is not answering legal questions, he is performing them. This scene becomes a perfect display of how sovereign citizens substitute ideology for substance.
I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for the entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. I started off Brian Ambrose's stopping.
Judge Coleman's patience begins to show cracks as he questions why Grayson would file a motion with a court he claims has no jurisdiction. The contradiction is so glaring that even the narrator jokes about the logic being warped beyond repair. Grayson insists the court lacks authority over him, yet relies on that same court to issue a ruling in his favor, a contradiction that exposes the core flaw of sovereign citizen thinking. This section vividly demonstrates how their arguments collapse under basic scrutiny, leaving them trapped in self-created legal paradoxes. The comedic commentary amplifies the absurdity, reminding the audience that these contradictions are not deep or philosophical, they're simply nonsensical. This part lays out how sovereign ideology breaks the moment it meets procedural reality.
And what is pertaining to, we are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's action being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michaels, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor.
When the judge clarifies that he is not a traffic judge, Grayson becomes even more confused, insisting he is sending information from 36th District Court, as though the unrelated documents somehow grant him leverage here. The sovereign citizen's inability to distinguish between different courts, different types of jurisdiction, and different legal processes becomes painfully clear. The judge politely tries to separate civil proceedings from traffic matters, but Grayson seems determined to merge them into a single conspiracy against him. This is where sovereign citizen behavior begins to feel like a loop, an insistence on blending unrelated concepts until even they cannot explain their own position. The commentary underscores how the judge's calm explanations only highlight the plaintiff's deep confusion.
That you failed to state of action upon which the court could grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular.
Attorney Michaels returns to the floor with structured point-by-point legal reasoning, dismantling the sovereign citizen's claims without theatrics. He explains governmental immunity, lack of a stated claim, and the improper collateral attack on traffic proceedings, all delivered cleanly and professionally. The commentary highlights how his clarity makes Grayson's arguments look even more like improvised rambling rather than lawful claims. It becomes obvious that the lawsuit is retaliatory, grounded in emotion rather than law, and that the attorney's explanation exposes this with effortless precision. This contrast makes the sovereign citizen's approach appear amateurish, almost childlike, compared to the disciplined reasoning expected in court. The part emphasizes how quickly sovereign citizen cases crumble when met with actual legal structure.